I invite Justice Manmohan to share with us his thoughts to set the tone and direction of our conversations this evening. Over to you, sir.
Thank you. Respected Mr. Jyoti Sagar, Ms. Kavita, Mr. Anil, Ms. Lohita, Mr. Rajinder Kumar, Mr. Zamir, Mr. Prashant Gupta, and Mr. Akshay Alag. First of all, I would like to thank the organizers for showing extreme patience. On 23rd April, which was the initial scheduled date for this discussion, I was detected with COVID. Thereafter, there was a bereavement in the family. I'm really humbled by the confidence that has been shown by the organizers in me. The topic is very interesting. In fact, copyright law has assumed great amount of significance in the recent years. Some years ago, I had read a quotation in Coppinger and James, which I think is very apt. It was to the effect that copyright is the Cinderella of intellectual property laws. A rich elder sister's trademarks and patents had pushed her for a long time into a chimney corner. Suddenly, the fairy godmother of invention endowed her with digital devices in an online world, just like her famous or magical pumpkin coach and the mice footprint. And now she's the queen of the IP laws. As a judge, or in fact, as a lawyer, I have wondered, why do judges sit on a higher pedestal? The only answer that I've been able to find is that they're supposed to look at the big picture and not lose focus. Consequently, I think the first point to be understood in this discussion or to be conveyed in this discussion is, what is the rationale or the intent behind the Copyright Act or the copyright law? The intent and the object is to promote human ingenuity and human creativity. Copyright Acts world over, including our Copyright Act, in a sense confers a bundle of exclusive rights on the owner creator and provides remedies in case the rights are infringed. Consequently, the copyright law promotes creation of works like literary, dramatic, musical, films, sound recordings by providing exclusive rights to the owners and creators. Jyoti just mentioned the 4 revolutions. And really, I think in this age of digital revolution, internet, big data, machine learning, the significance of this act has increased manifold. In fact, in the short opening, I will try to examine or just try to flag before you these scientific and technological advances that have taken place, both in the context of piracy and the copyright law. First, let's deal with the issue of piracy. See, digital devices in a virtual world have ensured a very large audience for creative works. But they have also facilitated copying at a scale and speed which was previously unimaginable. Distance and national boundaries have today ceased to exist. Piracy is a global epidemic. Jyoti just pointed out the figures, and when I was doing some matters, a lot of figures were pointed out to us, and really, the situation is pretty bad, and India is no exception. The general industry evidence appears consistent with the hypothesis that digital piracy has hurt the industry world over. But there are many issues that one has to grapple with. One is whether online world is the same as a physical world. Many scholars believe that internet is a unique highway or a separate space, which they call the cyberspace, to be left totally free, without any controls, unrestricted. They believe this space should be left free to be used by an infringer or by a law-abiding citizen simultaneously. And they give the instance of a highway. Say whether a dacoit uses it or the policeman uses it or a law-abiding citizen uses it, you don't touch them. Followers of this school believe that internet is first and foremost about individual freedom, not about collective responsibility. They believe that if an intermediary or an internet service provider is tasked with the responsibility of identifying and taking action against infringing content, it would have a chilling effect on free speech. However, in my opinion, and that's what I said in a judgment also, that if the view of the internet exceptionalists, as they are called, is to be accepted, then a boon like cyberspace could turn into a disaster. Courts normally have been applying the principle of necessary and proportionate application while dealing with the issue of piracy and infringement. This test or principle requires a fair balance to be struck between competing fundamental rights. That means the right to intellectual property on the one hand, and the freedom to trade and freedom of expression on the other. Just as supporting bans on import of ivory or cross-border human trafficking does not make one a protectionist, supporting website blocking or sites dedicated to piracy does not make one an opponent of free and open internet. Consequently, advocating limits on accessing illegal content does not violate open internet principles. There is also another view, which is that many believe that website blocking is an exercise in futility, as website operators shift the sites, and therefore they say any action taken is like a whack-a-mole effect. But countries which try to protect intellectual property rights have tried to deal with the menace of digital online piracy by working with internet intermediaries as the main solution. Sometime back, I had an interesting occasion to deal with the concept of dynamic injunction in UTV software matter. Just to give a little background, suppose a court were to pass an injunction against a website called T. T does not appear in court, does not defend the action. But what it does is, it creates a mirror website by the name of T1 and diverts all the business and all its activities, its customers to T1. These mirror websites with alphanumeric variation have the same content what the initial infringing website had. So by using this dynamic injunction, what the plaintiffs tried to do was they tried to use new means. They tried to block new means of accessing the same infringing material. So there is piracy which is on the increase, and due to scientific and technological advance, it is difficult to meet that challenge. But some innovative thinking has to go into it. And that I saw when this dynamic injunction concept was shown, and we tried to put it in practice in India. At another level, science and technology advances are challenging the core concepts of intellectual property laws. As I said, the real essence of copyright law is to promote human ingenuity and human creativity. But when machine starts creating works, then what happens? I recently heard of digital art and the new rules of digital ownership. The concept of non-fungible tokens. If nearly your whole world is virtual, it makes sense to spend money on virtual stuff. You must have read about the increased autonomy of artificial intelligence in the creation of artistic works. Interplay between AI and IP laws, in particular, the possibility of providing IP protection to AI-generated inventions. Last 2 years have seen the emergence of several high-quality AI-generated creative works. David Cope's ME, which he calls the experiment in musical intelligence software, has created realistic melodies in the style of Beethoven and Mozart. An artificial neural network has created a sophisticated artwork in the style of Raphael. And an AI program in Japan wrote a short novel that has passed the first round of national literary competition. Consequently, the advance in science and technology is impacting us in more than one way, and not necessarily in the same direction. As I said, at the one end of the spectrum is the increase in piracy, and the other end of the spectrum is the challenge to the fundamental concept of copyright law. In either situation, law is lagging behind technology by a few light years. And I think this is the point, in essence, which Mr. Jyotisagar also emphasized. Another challenge one faces, and when you sit as a judge, you're hearing all these matters, you find is that while IPR laws are territorial, they can be violated by an infringer just because he has committed the infringement through a server hosted abroad. And he knows that courts where infringement has taken place will take no action against him. And what you find is the moment the infringer jumps jurisdiction, it is difficult to take action against him. Keeping in view this, I don't mean as a High Court judge, but as a student of law, I feel it is time for a neutral agency like United Nations or WIPO to prepare a model IPR law for the entire world. After all, United Nations Commission on International Trade Law adopted a model law on international commercial arbitration and conciliation rules, which was subsequently adopted by a number of countries, including India, with certain modifications. So, in conclusion, I would like to say that Copyright Act is a very important act. And as Kopinjo said, it whirls through the mad maze of a glamorous hall at this moment. And we really need to keep pace with the ground level reality, which I think is changing very, very fast in that. And in the next 10 years to 15 years, with 3D, cryptocurrency, and all the inventions that are taking place, many fundamental concepts are going to be challenged. We really need a good relook at them. Thank you.